Counsel, it would seem that this case is a facial challenge. And to some extent, it relies on the overbreadth doctrine. But that seems to be an odd fit since respondent represents virtually all of the platforms, and that it would be easy enough for a platform who's affected to bring it as applied challenge. Would you comment on that? Or at least address the fact that this is a facial challenge?
Certainly, Your Honor. I do think that's a very significant aspect of this case. It comes to the court on a facial challenge, which means that the only question before the court is whether the statute has a plainly legitimate sweep. I actually don't understand them, Your Honor, to be making an overbreadth challenge, which, as I understand it, would rely on the effects on third parties. As I understand it, they're principally relying on the effects on their members. If they were bringing an overbreadth challenge, they would have to show various third parties.
Well, I think how would they do that when they haven't shown that there's no way that this statute can be applied that's consistent with the Constitution? Have they met that?
They certainly have not, Your Honor. I mean, and we think the statute has indeed a plainly legitimate sweep. And certainly there are a number of the platforms that are open to all comers and content, much like a traditional common carrier. And just as a traditional common carrier, consistent with the First Amendment, would be subject to hosting requirements, non-discrimination requirements, so too we think that the platforms that satisfy that characterization, which are a number of them, absolutely would give this statute a plainly legitimate sweep.